Stephen and I have found it absolutely invaluable spending the past 2 days here, listening to the eminent speakers and getting a real insight, a genuine insight, into the views and concerns which they, and which you, as attendees and through your questions, have expressed. As the Chairman stated in his opening remarks, the inquiry's priority is to discover the truth. Ever since the inquiry started work, it's been a primary objective of the team to achieve this by engaging with all of those people who have an interest in the subject matter of the inquiry. We recognise that the inquiry process may not be well understood by many of the people we need to engage with. It is, after all, rather different to the process in adversarial proceedings, for example, civil damages claims or criminal proceedings. And, speaking as someone relatively new to the process myself, it can appear complicated at times. Therefore, another of our key objectives is to demystify how the inquiry works, to explain clearly the processes that we are following and we are going to follow. In this way, we want to ensure that those engaged with the inquiry can understand these processes and are able to help us navigate our course in the most effective way. We will strive to ensure that this two-way dialogue continues as the inquiry progresses over the next couple of years. The conference agenda for this describes this slot as an official update from the inquiry. In the spirit of this, I will now do my best to describe the scope of our work, the steps we have taken to date, the progress we've made, and our next intended steps. I know that many of you will already be familiar with the terms of reference for the inquiry. It's worth reminding ourselves how wide these terms are. We are tasked to, and I quote, inquire into and report on undercover police operations conducted by English and Welsh police forces in England and Wales since 1968. That is a period of 48 years. Our task will cover the work of the Special Demonstration Squad and the National Public Order Intelligence Unit, but it is not limited to their work. As you will know, some of the activities we have to consider have already been subject to some scrutiny, for example by Mark Ellison QC or by Operation Herd, but many have not. By the terms of reference, we've been asked to pay particular regard to 6 specific aspects of undercover policing. Crudely summarised, these are as follows. 1. The role and contribution made by undercover policing. 2. The motivation for and effect of it upon individuals and members of the public. 3. The adequacy of the justification for it. 4. The state of awareness of the tactic across government. 5. The oversight and governance applied to it. And 6. The selection, training, management and care of undercover officers. The terms of reference specifically provide that if we identify any cases where a miscarriage of justice may have occurred as a result of undercover policing, we then have an obligation to refer those concerns to a miscarriages of justice panel. Therefore, the inquiry itself will not be responsible for any formal investigation in the event of a possible miscarriage of justice. As well as the 6 areas noted above, it's important that we continue to bear in mind that we've also been asked to identify and assess the adequacy of the statutory, policy and judicial regulation of undercover policing. In an attempt to break down the rather daunting nature of the scope of the task required of the inquiry, in his opening remarks made on the 28th of July last year, the Chairman announced that the inquiry would adopt a modular approach. This could be summarised as follows. The first module will cover what has happened in the past. The second module will then investigate systemic issues affecting the use of undercover police, such as selection, training and oversight. The third and final module will consider, informed by and drawing lessons from the first two, how undercover policing should be conducted, managed and governed in the future. Over the last few months, a large part of our work has involved determining preliminary legal issues. I will speak about our progress on these issues first, before I update you on the steps that we've taken to seek, preserve and receive evidence. In respect of each preliminary issue, we have circulated a note from Council to the inquiry, received submissions from those interested in or affected by the issue, and, where necessary, we have had hearings to allow the inquiry chairman to hear argument on the issues. For example, on the 7th of October last year, we had a hearing to decide who should be core participants. There are exactly 200 to date. And on the 4th of November, we had a further hearing to determine legal representation on which of those core participants should receive public funding, public expense for their legal representation. To date, just to update you, the inquiry has appointed 16 recognised legal representatives who represent the interests of 174 of the core participants. We also sought submissions on the standard of proof that the chairman should apply when deciding issues of fact. As outlined in a note drafted by Council to the inquiry on the 16th of December, the question was whether the standard applied should be the criminal standard, that is beyond reasonable doubt, the civil standard, the balance of probabilities, or a flexible standard. In the event, there was little substantive difference between the position adopted by any of the core participants on this issue, and therefore the chairman decided, in a ruling issued on the 13th of January this year, to adopt a flexible standard. The next issue which has been considered is the legal approach, in principle, which should be taken by the chairman when considering applications for what are described as restriction orders. A restriction order is the legal term given to the power conferred on the chairman by Section 19 of the Inquiries Act 2005 to prohibit, by order, the disclosure or publication of any evidence or documents given to the inquiry. As might have been anticipated, this was an issue on which there was a substantive difference between the positions adopted by state and non-state core participants. Following the service of submissions and evidence, there was a two-day hearing on the legal arguments around this issue on the 22nd and 23rd of March. Some of you, in fact, may have attended this hearing. I know that some of you did. Others may have read reports in the press about it. As the length of the hearing suggests, detailed argument was advanced by all parties. The authorities bundle alone contained 140 separate references. As with all of our hearings to date, a transcript of each day of the proceedings is on the inquiry website. I realise that my reference just now to 140 authorities may not provide much encouragement to everyone to rush home and read the entire transcript, but the clear articulation of the separate positions was to the credit of all those who spoke and of all of those on whose instructions they acted. You may be disappointed, but probably not very surprised, to learn that I'm not able to say anything about the way in which the chairman is likely to determine this issue. We anticipate that his ruling on the issue will be circulated on the 3rd of May, although if it's ready to issue before that date, we will do so. Once this ruling has been issued, the inquiry will start to progress the individual applications for restriction orders that it's received to date. It is at this point that the question of whether the identities of undercover officers, real or assumed, can be withheld from publication will be addressed. So that is the point which I know is at the forefront of the concerns of many of the speakers today and yesterday. Directions setting out timelines for the service of further evidence and submissions in connection with this were issued on Friday just gone, and again these appear on the inquiry website. At this stage, both those making an application for a restriction order and those seeking to oppose it will do so with the benefit of knowing, from the ruling of the 3rd of May, the legal principles that the Chairman will be applying and the way in which he will approach these. Moving on from the issues around restriction orders, the next hearing, on the 27th of April, will consider the scope of any undertakings which the inquiry should seek from the Attorney General. These undertakings would cover the use to which evidence given to the inquiry can be put in any future criminal investigation or criminal prosecution. The benefit of undertakings to those giving evidence would be to allow witnesses to give evidence freely, in the knowledge that anything they might say in evidence before the inquiry about their conduct could not be used in a future criminal investigation or prosecution. This would also ensure that the inquiry received from each witness all of the evidence which is relevant to its deliberations. At that hearing on the 27th of April, the Chairman will also consider the particular argument that protection should extend to evidence provided by a non-state witness about any conduct, whether by themselves or by others. Any undertaking would ultimately be provided by the Attorney General, as he has the power to decide whether a prosecution ought to proceed, and he is intending to be represented at that hearing. The final preliminary issue announced to date relates to the way in which the inquiry should treat the issue of the use of the identities of deceased children by the police. Should a hearing be necessary, this will take place on the 22nd of June. In this regard, the Chairman will have to consider, firstly, whether the state has a duty to disclose to the parents of a deceased child that their child's identity was used for police purposes, and if there is a duty, if there is a public interest test to be applied in deciding that, what does it comprise and how should it be measured? The above preliminary hearings have therefore set some of the foundations of the work for the inquiry going forward. Alongside our work on the preliminary issues already described, we've also already sought to identify, preserve and receive evidence relevant to our tasks ahead. We already have a large volume of documents from a number of public bodies, principally police forces. I appreciate that not everyone may be familiar with the statutory powers that the inquiry has to obtain evidence, so I thought it would be helpful to explain a little bit about the process that we've followed in order to progress our investigations. All of this, namely what I say, will be more formally documented and evidenced in due course. The first thing that we've done is to establish what categories of documents are held by an organisation, how and where they're stored, and what steps are being taken to ensure that they are properly preserved. For example, which computer systems do they operate? If paper files exist, where exactly are they held? And what precautions have been taken to ensure material potentially relevant to the inquiry is being preserved? Once we have established what material is held, we can make a formal written request for evidence under Rule 9 of the Inquiry Rules, the Rule 9 request, as described. This may be a request for a witness statement or a request for particular information or evidence to be provided within a certain time period. We have already issued 122 of these requests and received a large number of responses. In the event that a person or organisation does not cooperate or respond to a Rule 9 request, the Chairman has the power under Section 21 of the Inquiries Act to serve a notice requiring a person to provide the evidence requested. A failure to comply with such a notice carries a criminal sanction. So far, our experience has been that organisations and individuals have almost invariably been eager to cooperate with the inquiry. Information has been provided willingly, and I'm pleased to say that to date there has been no need to serve a Section 21 notice on an unwilling organisation or individual. Of course, we are keenly aware of the concerns that have been expressed in the media and elsewhere about the risk of documents being destroyed or withheld, particularly by police bodies. These concerns are understandable, particularly given the issues which Mark Ellison QC encountered and identified in his report. We do take this issue extremely seriously. It will be of paramount importance that when the inquiry delivers its conclusions, that these are reached and, as importantly, can be shown to have been reached on the basis of full and frank disclosure having been made to it. Under Section 35 of the Inquiries Act, it is a criminal offence for a person to suppress, conceal, alter or destroy a document in the course of an inquiry where the document is relevant to the inquiry's work. We have reminded all of those from whom we've sought evidence or assistance of the importance and effect of Section 35 and the need for them to be able to show that all relevant documents have been preserved and produced to the inquiry. We also circulated in January of this year a draft protocol for disclosure. This is still under consideration and discussion. We are considering particularly the comments we received on behalf of all non-state core participants. This protocol deliberately places a specific requirement on the Metropolitan Police Service to keep the inquiry team informed as to the steps which it's taken to preserve information. I should add that we have inspected the document systems operated by the Metropolitan Police Service Operational Home, and we have also asked for and been provided with signed statements covering these issues, and these statements will be published by the inquiry in due course. As I hope all of the above illustrates, we've put steps in place to be as transparent as possible. We are a public inquiry, and we therefore aim to publish as much as we can about our work and the way in which we are conducting it. For example, as I previously mentioned, all of the transcripts of all of the hearings to date have been published on the website immediately following the hearing and remain there. Although the layout of the website is evolving as the inquiry progresses, I do commend it to you as a one-stop shop or a library for the published materials of the inquiry to date and the transcripts, rulings and other orders issued in the course of our business. We will continue to keep this website up to date. As part of the evolution of that website, we will be inviting feedback on its usability. Please do feel free to email us with any views or suggestions you have about it. That is a brief summary of what the inquiry team has been doing so far. Looking ahead, we will continue to secure documentary evidence from public bodies. We will also need to gather evidence from core participants and from witnesses. In due course, a list of issues will be prepared by counsel to the inquiry. The purpose of this document will be to help structure the inquiry's work and to allow us to focus our investigations in the lead-up to oral hearings. It will not be set in stone, and people who have an interest in the inquiry will be invited to make suggestions about possible further issues. Of course, as the inquiry progresses, it might be appropriate for new issues to be added or for existing issues to be removed, depending on the evidence that emerges. Thank you for listening today, and thank you to the conference organisers for inviting Stephen and I to attend. Looking ahead, we are very keen to continue the process of engagement with everybody. We are very happy to respond to any inquiries directed through the inquiry website, and we'll be very happy to attend further events relevant to our work, provided that our attendance was considered helpful and welcome. That is the end of the paper that I was due to deliver today. There are two further points that I'd like to very quickly make. The first is that we propose to post a copy of the paper that I just delivered on our website a little bit later on today, so that anyone who was unable to attend today, or anyone who would like to review it, will have the chance to do so. The second thing that I'd like to say is, again, we're very grateful for you for inviting Stephen and welcoming us to our conference. We found it extremely useful. However, we note that there is a discussion after this, which various of the recognised legal representatives will attend, which it appears gives a platform for those concerned with the inquiry to express views. And it seemed to us the right thing to do to withdraw after you've had the chance to ask us some questions, to give you the freedom to do that away from the inquiry. But my original invitation to respond to any inquiries through the website or otherwise remains open. So that, I think, concludes my presentation. Thank you for listening.
Thank you, Piers. Obviously, we're going to take questions and answers, so if you put your hands up, I'm going to take two questions at a time. Sukhdev and Merrick, so we start from there. And I will take every single question if I can in the next 15 to 20 minutes. That's Sukhdev there. Hello. Sukhdev, if you can speak a bit loudly so we can hear.
Why is legal aid issue unfair for people who are non-state, non-police corps participants? I want my own solicitor with me when I need him, but because of legal aid issues, it's impossible for him to be with me when I need him.
The question on?
Yes,
sorry,
let's just take two questions at a time. Do you want to clarify?
The second question is, I think you have answered it partly. When are you going to give us the names of the police officers involved in our case? I mean the names they used when they spied on me, their real names, and I need to be shown the photographs, because if you come to me and say, this is John Smith, I wouldn't be able to recognize him. So if they were carrying identities, as you said, they were, given papers and everything, so surely they have photo IDs. So I need to be shown that.
Yep.
And also, the inquiry needs to be a public inquiry. If it's going to be heard behind closed doors, then they need to change the name of the inquiry. It can't be a public inquiry. Thank you.
Thank you. Just take two questions at a time. Are you taking them down?
Yeah. The business of the units you're looking into was to be liars and to prevent discovery of their lies. And we've seen as they've been exposed that they've put women that they've victimised through 5 years of a really gruelling legal process, throwing every obstacle they can to prevent accountability and disclosure. They do not want to be giving you disclosure, and they are holding the documents. And you've just said it's a criminal offence for them to destroy documents. Earlier this year, we heard that Sergeant Williams from the Domestic Extremist Database flushed his career down the toilet by whistleblowing and saying he saw documents being destroyed. This is what they do, and you are trusting them, who have such a long history of destruction of documents. And it's a criminal offence to destroy. They're not afraid of criminal offences. They committed criminal offences. I was with Mark Kennedy committing criminal offences. That's what they did. They're not scared of that. How will you know if they've destroyed the documents? Because they're destroyed. You are trusting them. You should not trust them. They are liars. They are duplicitous. They need to be requisitioned now.
Do you want to use this to answer? It's just hold it near your mouth, that's all.
Okay, right, we'll give it a go. Thank you. So I'm going to deal with the first question first.
No, Chris.
Oh, sorry.
One does.
So that's.
Might be good. Yeah, that's it.
Okay, let's be green.
Okay, good. So I hope you can hear me.
You're a bit close.
Good.
Just a little bit closer to you.
Oh, sorry. I hope this is all new to me, I should say. Right, I'm going to deal with the first question that you asked Mrs. Reel about legal expense, because essentially that's my area of responsibility, or one of my main areas of responsibility. As I've said, we have made cost awards in favour of a number of recognised legal representatives. The test which applies is quite simple to remember, thankfully, and all that need to be applied are the dual limbs of reasonableness and proportionality. And if time is reasonably and proportionally spent, then that cost will be reimbursed. So, and as I understand it, you do have the benefit of a legal representative. So that is there. If there are concerns, then what I suggest you do is invite your representative to contact me, and we can discuss it in that way. That might be the safest way to do that. Okay?
I think Mrs. Real is talking about having one QC between 170 core participants.
And one solicitor as a coordinator during the last hearing.
Yes.
That's what she's talking about.
Okay, I see. So, sorry, that's a slightly separate point. Well, as you know, the hearing that we've just had was an in-principle hearing, and the conduct of the inquiry, I mean, the inquiry is quite a formal process, is left to the chairman. The chairman's view, as he expressed it in his ruling, was that there were two countervailing positions, essentially the state and the non-state position, and that is why we arrived at the original groupings of having one representative for the non-state parties. There were, in the run-up to the hearing, a number of applications for additional representation, some of which were successful and, for example, resulted in the attendance of Mr. Squires, and some of which were unsuccessful. But all of those were considered by the chairman, and he provided a reasoned decision to them. Whether you agree with that, I suppose, is a matter that I wouldn't comment on, but all I would say is that where someone feels there is unfairness, they shouldn't feel precluded from making a submission to the chairman, explaining why they think it's unfair, and he will, in my experience, come back with a response setting out his position. All right, so I appreciate that may not answer the question, but that is the process that he's adopting at the moment. So I'm going to pass this now to Stephen, who I think will deal with the issue of restriction orders.
Yes, thank you. So your question was about releasing the names and photos of the officers. I can't really add a huge amount to what we've said already. We've set up a process, and the recent hearing on the 22nd and 23rd of March was the latest stage in that process to allow the inquiry chairman to consider the legal principles to be applied to applications for restriction orders. And what will happen next is that individual applications will be made for there to be restriction orders, and we'll just have to deal with them individually as and when they come along. And the legal principles will emerge as that process takes its course. Over time, we'll have a clearer picture of how the inquiry will be dealing with this. But I can't really say anything today that's going to preempt the inquiry chairman's ruling. And as we've said, that's coming out in early May.
But this is about the cover names, this is not the real names. It's just, we want to know how many people have been spied upon and how many people want to make an application to be a participant. How can they do that without knowing who have spied upon them? We don't need their real names, we want their cover names. We want the list of 460 organizations that have been spied upon.
Yes, I understand. I understand that, but it's part of the same process. It's not a separate category of document or identity. It's part of the same process, and the structure we're setting up allows argument to be developed according to that process.
Okay. Have you answered no?
Does that cover it?
We're going to answer that.
We will allow every single question. I'm not going to stop anyone. Yeah. Just Mark's question.
Yeah, okay. Sorry, is that document?
Yeah, sorry, just while you're locating the next question, the gentleman back there asked about, was asking about the preservation of documents.
Can you just...
Just to comment on that, I mean, the preservation of documents is essentially the issue which arises in the disclosure protocol which has been circulated. The disclosure protocol represented the way in which the inquiry proposed dealing with the receipt of information. And I know that we've received substantial comment back from the non-state, non-car participants. Those are presently under consideration, and the issue is not determined. So I'm well aware, as I say, firstly, that there is a high level of suspicion, and that's probably, even that is probably understating it, amongst the core participants about the way in which the police will preserve documents. And we simply need to establish, by following a fair process, the best way in which we can receive that evidence, so that at the end of the day, the inquiry can show that not only it's had all of the material, but that the way in which it has recovered it is shown to be transparent and complete.
Can you answer the question?
Your question, as I understand it, was why don't we simply, to use your word, requisition the documents now?
They need to be independently held away from the police who are being investigated. No other criminal will be allowed to preserve their own evidence.
Yeah, well, I understand that point, and that point has been made and is presently being considered by the inquiry, by which I'm in the chairman. I'm sorry, I can't provide any further answer than that.
Just can you put a show of hands so I can see who wants to speak? Okay, there's people there, Kate, and then Helen, and then Mike. If you just take 3 questions. Okay.
Hello. Well, first of all, to say thank you for explaining some of the really complicated stuff about the inquiry, that it is often difficult to understand, and for the commitment to transparency. But I hope you're aware that it's not actually the work of the inquiry that people really want to know about. It's the work of the police, and it's not going to be enough to be terribly transparent about how the inquiry is working and the police be able to hide behind that and keep their secrets. I wanted to make a couple of comments. One is about, I was at the hearing last month in Court 73, and I just wanted to make the point that for an inquiry with, as you said, 200 core participants, the hearing was held in a room with only 50 seats for the public to take part. And I think, and there was an overflow room, but it's not acceptable that people get to essentially watch it on television, because it's not just about the people being able to come and hear what the inquiry is saying. It's also about the chair of the inquiry being able to see the people who are interested and the reactions that they are having. Secondly, I would like to make the point that and this has been made before and is probably a point for Theresa May rather than for you, but just to reiterate that the terms of reference that look at infiltration by police forces in England and Wales, is completely inappropriate. The majority of the police officers that have been discovered today all worked outside of England and Wales, and there appears to be a concerted attempt to cover up the cooperation that's going on between the Metropolitan Police and other police forces in Northern Ireland, in Scotland, and in other countries around the world. And that's a big hole that's going to be in the inquiry unless those terms of reference are looked at. And finally, I wanted to ask about the role of the CPS, because you mentioned miscarriages of justice, that if there are miscarriages of justice, those are going to be referred to the CPS. The CPS are currently not listed as a core participant in this inquiry, and I think it's kind of shocking that they're not, and in the miscarriages of justice that have taken place to date, the wool wasn't pulled over the eyes of the CPS. They were absolutely complicit in those miscarriages of justice, and I don't think they're appropriate. Simply handing over cases of miscarriage of justice to the CPS is not enough, and I hope that there are, I think you said, Section 9 requests going to the CPS as well to get disclosure of exactly what their role was in that, and I hope that they will be required to give evidence to the public inquiry as well.
you go on, I'm just going to let Piers or Stephen to answer Kate's points. She's raised 3 points. It's better if they answer that, then I'll come to you. All right?
Thank you very much, Kate. One of the real benefits of coming to this conference over the past 2 days is to listen to and to be able to take back the views of the core participants and those interested. We know from the last hearing that there was unhappiness about the way in which the hearing was, when I say conducted, what I mean is about the hearing room, bluntly. And, you know, what you've said today chimes with that, and I will again take that back to the Secretariat as you know, a valid comment, I think. We want to get it right. You know, what we don't want is an overflow room which has to be staffed, etc., which is empty. You know, we need something which is effective and which meets the needs of everyone who wants to be at the hearing. So we're finding our way on that, but thank you for your feedback on that. Unfortunately, probably, I have to agree with you about the second point, namely the ambit of the terms of reference, limiting themselves to England and Wales and English and Welsh forces. We're a creature of statute and we have to do what the terms of reference say. We are aware, of course, that there's a discussion going on around us so as to speak about that. And as you can imagine, we are interested observers as far as that's concerned, but I don't think I can say more than that. As far as the CPS is concerned, I suppose there's 2 aspects to that. They're not listed as a core participant. I was saying to Evelyn at lunchtime that sometimes I think there's a bit of a magic aura around the phrase core participants, and there is a perception that if something or someone is not a core participant, then we're not interested in them and we're not dealing with them, and you know they're out of the picture. And nothing could be further from the truth. We can't force anyone to be a core participant, but those who meet the test and who have applied become core participants. So the fact that the CPS are not a core participant, of course, doesn't mean that they're outside our investigations, and they are someone who we have been in contact with and will remain in contact with. The second point, I think, was about miscarriages of justice. There's a specific body, as I understand it, which is a committee comprised of the Home Office and the CPS, who would consider miscarriages of justice as and when we identify them. And I think that is, I'm not sure how...
They were the people responsible for the miscarriage of justice in the first place, is my point.
Right, well, I understand the point you're making. However, the terms of reference simply say that we identify and pass on to that body what they are. Whether that is a good arrangement or a bad arrangement is probably for someone paid more than I am to say. All right, but thank you.
Who does say that then? So
Jason, I'm going to give everybody a chance, but Helen, go on.
Okay, it's actually coming back on points that Mrs. Reel and Kate have made, but firstly, in terms of the venue, there was not even enough space for core participants, but additionally, there was no desks for core participants. And if people want to participate fully, they want to be able to take notes, and they may want to plug in their computers or whatever. So that needs to be in the room where the inquiry is going on. Enough space for everybody to take part fully. Secondly, in terms of the inquiry not covering what's going on in other countries, what the undercover officers did in other countries, how are you going to deal with the fact that when we were in relationships with these officers, we actually went to Scotland, Ireland and other countries around the world? What are you going to do? Just not hear that evidence? It's a whole part of the story. You know, that needs to be included. The actions that they undertook abroad are significant and serious, and if you don't look at them, you won't get the whole picture. Finally, to come back on the point that Mrs. Reel made, there is a massive inequality of arms already in this public inquiry. The police have been keeping sustained files on us for years on end. We've got very little on them, apart from what we've managed to kind of cobble together. And you're now compounding that situation with lawyers, where the police and the state are represented by a large number of lawyers, all paid for out of public funds, whereas all the non-state core participants are expected to deal with like one lawyer you know, okay, we've got our own solicitors, but you wouldn't pay for them to be at the last hearing, which then means that, you know, how do we get effective representation when one solicitor doesn't know all of our stories and can't possibly... And also the fact that we're all, as you've said, there's 200 core participants. We come from a wide range of backgrounds, a wide range of locations, and a wide range of political views. So to expect us all to be able to reach one agreed position and in a very short space of time is actually unrealistic. We need separate lawyers to represent our interests.
You go through the three of them.
Thank you, Helen. Yeah, the first point, which is, as I understand it, the venue again about having desks for computers. Yes, of course, I'm happy to take that view back, and we will need to look at the way in which we are accommodating, so as to speak, the hearing. So, yes, Stephen's reminded me that Court 73 is the biggest court in the Royal Courts of Justice, which... well,
that's the point.
Actually, the most accommodating place.
Yes.
People who are not state participants anyway.
Yeah.
So perhaps it's not the most
I think I understand the point you're making, which is, even if it is, it's not quite right at the moment, and we need to look at that.
When you look at it, I don't want to put you in an odd position. When you say when you look at it, what does that actually mean?
Well, it's a good question. I'll take the comments back. The chairman directs the inquiry, so he will have a view about how and where it should be conducted. We have a secretariat of people who work hard to make sure the practical day-to-day things happen, and it seems to me that they might be able to scope other opportunities to find out what the realms of possibility are. Then we'll have to look at that. No doubt, cost will come into it, convenience, but also the weight of argument admitted by the core participants. So it's just a normal structure for making a decision about where a hearing should and could be accommodated. Almost invariably in these situations you look at how other inquiries have conducted themselves, so it might be there is things we can learn from there.
On that point?
Oh, the second point.
Sorry.
Yeah,
Mike, did you want to intervene on
that?
that?
Can I short circuit this? What is disappointing, I would say so, I'm glad that you're here. I've been here before. We've had inquiries before. Court 70, I've been in Court 70 numerous times. That's not the place for it. And somebody on the inquiry side should have already been thinking about other venues. And I can give you a list of them. Central Hall, Westminster, was used for the Paddington inquiry, for the Bloody Sunday inquiry. The one next door, which is the Queen Elizabeth Conference Centre, also has facilities of which I did the Diana inquest, several hearings in there. Plenty of space. It needs, of course, money spent and allocation and availability. I've only touched the surface. This should have been sorted, I'm afraid to say, before today.
I just want Piers to answer Helen's second and third points, and then I'm going to come to Mike and other people. I'm going to give an opportunity to everyone to speak. I know there are people on that end as well. Sorry?
Oh, sorry. Yes, sorry, for one ghastly moment there, I couldn't read my note of the second point that you'd raised, Helen, but I've now identified what I've written down, and that was in relation to other countries and where that forms part of the narrative. The honest answer is it will be a matter for the chairman to decide what he looks at, but it does seem to me counterintuitive if something which takes place in another country forming part of a longer narrative is something which will just be put out of the picture. So I think that's, I would imagine that would be considered, but I can't speak on his behalf, of course. The third thing that you talked about is equality of arms, and repeated the comments of Mrs. Reel. I can't obviously go on repeating myself. You know that the chairman's considered these issues. What I think I would like to say, in fairness, is that at the moment we are dealing with preliminary issues and issues of principle. Things, I'm sure, will be different when we are dealing with the specific circumstances of individual cases. And at that stage, as you say, the different stories of the core participants will be highly relevant, and the need for individual representation will be all the more acute. I appreciate that's not a complete answer, but I think it is a distinction that's worth bearing in mind and pointing out.
Well, it isn't, because the personal experiences inform the principles that are being developed, and they need to be, people need to be able to speak to their lawyers and get their lawyers to convey that to the barrister in order for that to come across during the hearing.
Yes, well, I take your point on that. As I say, there were a number of applications which the chairman considered in the run-up to the last hearing, so I can't really say anything other than he has said in response to those applications.
Mike?
Yes, sorry. I've got one
Can you get the
issue.
microphone there, please? Just wait.
Do I need it?
We can hear you, Mike.
I think you can. Can everybody hear me? Right. It's to do with the preservation of evidence and access to documentation, electronic and paper. And the problem as I see it, I'd like to know what, as much as you can give us, as to how this operation is being conducted. Because if you serve a Section 29 notice, what are you doing? Saying, please give us everything you've got. Or are you saying, we need the following documents? How do you know what documents to ask for, unless there's been some kind of leak of what they are? And effectively, it's a circular situation, and I've had it in other situations. In other words, how do you know what is not being disclosed? At the heart of the Lawrence inquiry was non-disclosure to that inquiry, which has only come out through the Ellison review. Now, my concern is, therefore, have you got, this is the second part of the question, have you got a team of investigators, and have you got a team of investigators empowered to go in tomorrow and actually say, we want to see what you've got, even if you don't get the full truth the first time. It's very interesting. Well, I can't say too much about Hillsborough, but interestingly, what has come to light since, lots of things are sitting around in offices under different titles, and somebody opens the box and says, oh, it's been here since 1931. And that's what, and it only happens when you go in. So what I'm saying is, are there answers to these questions? If I've missed it, I apologize.
They seem to go in unannounced as well. That's what they do to people on the street. They're unannounced, just go in. Just go in.
Well, the position with documents so far is that we have had one of the council team going in and going through the computer records of the Metropolitan Police and the documents held by Operation Hearn. So that process has started, and it's linked to the way we target requests for information. We're still at a relatively early stage, but that's what we are doing. But to answer the person's question up there, we don't have power to, raid premises or enter them. It has to be a process that's done in this way, and we've explained the powers we do have under Section 21 of the Inquiries Act, and the lead up to that, which is the Rule 9 request. And if we're suspicious, we can follow them up. I mean, that's all I can say at the moment. And as I said, we're relatively early stage, and this isn't just about the Metropolitan Police. We're doing it with police forces all around the country, all 43 of them. So.
Just 1 minute. We are about. If we are going to have a coffee break, we can have it now and come back, and we can ask more questions. Otherwise, the coffee staff are going to leave at 4 o'clock. So really, we need to decide whether we want to continue with this session after the break or we finish in about 5 minutes. If you want to ask questions, I'm going to allow about 2 questions, and then finish the session and go for a coffee break and come back. Is that fair? So, that gentleman there. Sorry, I've had one lady there and then Satish. I can't get, sorry, I can only get about 2 questions.
Sorry, could I just say as well, as you know, as I said at the end of my thing, what we're planning to do is to leave sort of around the next coffee break. We're happy to sort of stick around for 10, 15 minutes if during the coffee break people want to just come and have a chat with us without raising something in the whole forum.
Yeah, it's very quick. How many successful prosecutions have there been for non-disclosure to previous inquiries, ever?
Thank you. That's a very short, sharp question. Just to hold on to that. Yourself and then Satish, yeah? Yourself? Very quickly.
Sorry, no, I just wanted to make a very simple point, which I think others have made much more effectively, but they seem to go, those contributions, to the heart of what may be a public confidence problem in terms of the inquiry. We saw that many years ago in the Scarman inquiry, when the Brixton Legal Defence Group achieved participation status. But one of the ancillary problems was ensuring that the community, that other community organisations had confidence in the process of the inquiry. And I do feel that some of the questions that have been put really go to the heart of that. The question of venue, for example, the ability of people who want to take part, ordinary people who want to take part, in being able to be present, in being able to see the chairperson, in feeling that their presence is wanted and that their presence is going to be respected to the extent that the facilities are going to reflect that. So, as Michael's already said, this is something that's happened over and over again. I do feel it's a critical...
Thank you. Satish, simple, quick question, if you don't mind.
I'll try. This is in support of what Mike Mansfield and Merritt have said. There is a case, one of the biggest police corruption trials this country has ever seen. And the case collapsed because the police were asked to find documents and ensure that they were disclosed. They failed to find them. The judge accepted that they couldn't find them. A month later, they were found in the box that they had been sent in originally by the IPCC, which basically means that the police did not even look in the box that they had been sent with. So I would ask you again, please, 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 do not take the police's word for what they are saying when they're around disclosure. And secondly, with the number of cases that there are, the other thing that you see with this particular case is every time you get close to actually exposing what has gone on in this particular case, another court case comes up and it all becomes sub judice again. Can you ensure that with the number of cases that are going to have to be dealt with in this inquiry, that it isn't simply going to become sub judice and put on one side because of court cases, and that it will effectively never ever report?
Thank you, Satish. Yeah, I'll come to you in a minute. Can you just get, where's the microphone? Sorry, we'll come to you. And that's the last question.
Yeah, thank you, panel. My contribution, like many of the delegates here today, isn't so much a question, it's more a consideration. Speaking as someone from Tottenham and the controversial death of Mark Duggan in Tottenham that I'm sure everyone in the room knows about, it's just to have the reassurance that the cultural considerations for the endemic racism that we know still pervades within the British police force is a serious factor that you must take on board when, as my colleague before me has just said, when you actually communicate with the police, be certain that somewhere, and God knows how you'll achieve that, you'll be able to find police officers of standing that will be able to give a representative account of their police practices to ensure that we do get out of this inquiry some justice, because I am apprehensive. We know of the Swan report, we know of the infamous McPherson report findings. So although this may be seen as an opportunity by Theresa May to improve public relations with the communities in the UK, there are still serious grave concerns, and we will be watching, and we hope that you will be able to represent all of us in the community so that we can get justice for the Duggan family, for Janet Alder's family, for Roger Sylvester, for all of those that have lost their lives in very dubious and suspicious circumstances. Thank you.
you want to go through the questions?
Thank you. I hope that I can remember and do justice to all of the questions. I think the first question was how many successful prosecutions have there been under Section 35. The honest answer to that is I don't know. I suspect it may have been a rhetorical question, but I would suspect or speculate that it is a very low number, possibly not even a number at all. But I think perhaps that's more of a point than a question, if I might respectfully say so, but I take it. The second, again, more comment from the lady at the front here. Again, we take that comment on board and we'll take that back to the inquiry. Thank you for making that point. The gentleman here, don't take the police at their word. I can assure you that we won't be doing that. We want to be clear about, having a proper audit trail which can be published as to what exactly has happened. We will make sure that we achieve that.
So I made the document.
Yes, and that's in that regard. That is what I mean as well. In relation to things becoming sub judice, being blown off course by other litigation, we are conscious that this report will lose its value if it takes too long to produce. We want to do a thorough job, but we also want to complete the report within a reasonable time period. So we will do our very best to ensure that we are not blown off course by those type of issues. I think, generally speaking, it is more difficult now to defer or delay the progress of an inquiry by virtue of other litigation. But we will bear that in mind. The lady at the back, yes, absolutely take on board the point about racism. It's been brought home very forcefully to us throughout the inquiry, but particularly over the last 2 days. We will always continue to be mindful of that issue and making sure that we cater for that as best we possibly can.
Okay, thank you. I'm going to take the break now. It's important, sorry. Just thank Piers Doggart and Stephen have agreed to be here. And I'm going to take, I just want an indication of how many questions. Just let me look. And obviously Janet isn't asking one. Does Janet, yourself, 2, 3? So I'm going to give 15 minutes to questions 4, to questions and answers, and see how we move forward, because they need to leave as well. And the cut-off point for the conference is 5 o'clock. Anyway, we have to leave this hall at 5. So, Janet, and then yourself, Suresh, is it? And then Marie, and then Jagdish. Okay? So we've got 4 speakers. Janet, first of all.
In the course of your inquiry, say you are dealing with core participants, and a lot of these people, the activists, have been at the same meetings at the same times. The police have been able to get information about where meetings have gone by picking up leaflets and whatsoever. In the course of that inquiry, if you come across any evidence that other people, other activists were at this meeting being spat at as well, what will you do? Can you guarantee that you're going to disclose that to the people, and what you're going to do about it?
Okay, you got that?
Yes.
Just wait for 2 questions each. Suresh? Just use the microphone, please.
Just specifically, have each of you read the Lawrence Inquiry Report in full? And secondly, you're doing a lot of activity that you described in your presentation, and that implies a team back behind you and supporting you. Could you talk about the race and gender demographics of that team?
Okay. Can we have these answered, then we can go to the other questions.
Yes, of course. So Janet's question first, and I had the good fortune to speak to Janet during the break, and true to her word, she's asked me the same question that we talked about then, so thank you, Janet. The short answer is, I'm afraid I can't offer any guarantee, but what I can say is this. If a document or piece of evidence that comes to light, the starting point is where a public inquiry, material submitted to us, will be public. That is subject really only to issues of privilege, or, which wouldn't apply in the particular example you're talking about, or an application under Section 19 to restrict publication of that evidence. And that would follow the process that I outlined a little bit earlier, where there would need to be consideration by the chairman as to whether any arguments to restrict publication could not be pursued, whether there were arguments that full publication would not be allowed but some sort of gisting would be allowed, or whether there were good grounds for withholding that document. And the way in which he'll approach that is what he's going to set out in his ruling, saying of the 3rd of May, although it'll be around that time it's issued. The gentleman there asked about the Lawrence Inquiry report. Have I read the entire thing? No, I haven't. I've read some of it. The chairman, however, has read the entirety of the report. I know that. And we are, familiar with that and the issues arising from it. In terms of the team, yes, there is quite a growing team, quite frankly, now. I haven't got statistics with me, but it is fair to say there is, in my view, well, let's answer that in two ways. Firstly, in relation to recruitment, we are mindful of our responsibilities under the diversity legislation, and we apply those in the recruitment exercise. And secondly, I think the makeup of the team presently does reflect that. I'm not going to go into specifics of names and details, but
Numbers. Men and people who are not white. Men and women and people who are not white. Just, you must have a sense of view.
Numbers.
How many are there?
How many on the team?
So how many on the team? Well, to put it this way, I'm the solicitor to the inquiry. I had a legal team that is constituted of paralegals and permanent lawyers, if I can put it in that way. In relation to paralegals, we have 4 female paralegals, one of whom is black. In relation to the lawyer element, we have, I'm just calculating this in my head, I think now 4 lawyers on the team, all of whom actually are male, one of whom is a black male.
Supplementary? Okay, just use the mic. Just a supplementary for me.
Are you all seconded from government departments? Are you seconded from government departments to the inquiry? The Macpherson inquiry, the people on the inquiry team, the secretariat were seconded from government departments, from the Home Office and different departments. Are yourselves and others in your team seconded from government departments?
The non-paralegals, if I can put it that way, yes.
And the other staff?
When you say the other staff, you mean the non-legal staff?
The non-legal staff.
I believe, I'm not so confident about them, but I think the majority of them are seconded, yes, correct.
Okay, thank you. Dr. Marisa, just wait for the mic, please.
I'd raise this briefly with you in the break, but I think it's an important question for everybody to hear the answer.
Yes.
What I wanted to know was, is there within the inquiry technical expertise in relation to discrimination, and particularly in relation to race and gender? Because it's a matter of being able to understand and interpret the evidence that's presented, and also being able to question, to elicit the appropriate evidence. Is that expertise present in the inquiry?
Well, the answer to that question is we're very aware of this as an issue, and at present we feel there is sufficient expertise to deal with what we've had so far. But if it comes to the stage where we feel the need to bring in more expertise, there are various options available to the inquiry. There are 2 examples I can think of. The first one would be that we could bring in independent counsel to assist the inquiry with specialist expertise in equality issues. So the second one would be to pay for similar representation by core participants to assist the inquiry. But failing that, and perhaps a more extreme option would be that the chairman of the inquiry has power under, I think, Section 11 of the Inquiries Act to appoint a formal assessor. But I don't think we're at that stage yet. But we're very alive to the point and the need for this to be covered. And it's very well within the ambit of the inquiry's work, because the terms of reference specifically include taking into account the motivation for undercover deployment.
The very point is that you don't know what you don't know. So if you're making the decision about when you need help, the experience of the Stephen Lawrence inquiry was that the inquiry was in train before they realized that they needed the kind of help that they needed, and that point it was brought in. But they had already seen witnesses at that point.
Yes, I mean, at the moment, as I described a little bit earlier, we're not quite into the evidence assessment stage, but I think your point is well made, and as with all the other comments, it's something we'll certainly feed back to the chairman as a result of this meeting, so thank you very much for raising it.
Just to add to that, I hope you don't mind me asking a question. There's a prima facie situation where the women were targeted because they were women by undercover officers. There's no question about that, is there?
There doesn't seem to be, no.
So
That's
if
right.
that is a fact, then surely you need expertise on sexism, just as an example, in how the Metropolitan Police targeted women, how they would be used, how they would be manipulated, how information would be sold. And you don't have that expertise at the moment, but there's a prima facie situation that exists. That's right, isn't it?
Yeah, that's right. I mean,
so you aren't at a stage where you don't know the evidence. You know that on that particular case, that's what exists.
that's right, but I think the point that Stephen and I are trying to make is we're not yet at the stage of looking at that evidence for that purpose. You know, we're dealing with the preliminary legal issues and preserving evidence. And, you know...
Sure, I understand, but
yeah.
I think Dr. Marie Stewart was saying is that although the Macpherson inquiry was looking at the racist murder, the evidence didn't exist at that moment, but they still had advisors prior to the evidence being disclosed. That's actually the point that she was making.
Yep. Okay, well, thank you for amplifying that, Suresh. Again, it's a point that we can take back and make sure is, you know, made clearly to the chairman.
I don't know whether you want to add to that, but I think it's been done. Jagdish?
Yeah, I've got a two-part question. You said earlier that you looked at the database of the Hearn inquiry. I met with the officers from the Hearn inquiry with the Veal family and had concerns about the quality of their investigation and, I assume, the database. So I wondered what else you've done apart from that. In particular, Section 35 of the Inquiries Act makes it a criminal offence to interfere with or destroy evidence. On the 8th of January, there was a newspaper article in which a whistleblower talked about evidence being destroyed within the fortnight. I just wondered what the inquiry panel has done to address this criminal act.
Shall I answer that?
Yes, please.
Thank you. Well, thank you for your question. I mean, as you say, it really raises, I think, two issues. So the first issue is Operation Hearn, and what actually have we done as far as that's concerned. As I say, we've visited Operation Hearn, and we have a clear understanding of what they hold. We have had that supported by a statement that we've received from them, setting out a chain of custody of the material that they have received into them, how it's stored, etc., the safeguards that they say they put in place. Now, a gentleman earlier was saying, you know, don't accept what the police say at face value. But I like to think by having visited them and having got that statement, there is some connectivity. And in due course, all of that will be open to public scrutiny, and that will be part of the disclosure protocol and process. The second question that you raised, you spoke about on the 8th of January, a whistleblower talking about the destruction of documents. I imagine, and please correct me if I'm wrong about this, that you're referring to the Jenny Jones position in the destruction of her documents. We in fact received, and forgive me, I'm not sure whether you're one of them, a letter written by Tamsin Allen on behalf of core participants asking the chairman what he'd done about that issue. We did issue a response setting out the steps that we'd taken to date vis-à-vis disclosure, which frankly amounted to what I've just said, namely the visiting of police forces, the obtaining of statements, etc., so on and so forth.
So is that right criminal investigation, basically?
So the criminal investigation that you're referring to would be predicated on the basis that what the whistleblower had said was right, namely that documents connected to the inquiry had been destroyed. But as I understand it, if that were the case, it would not be, the inquiry doesn't have the power to conduct a criminal investigation itself. Now, I fully understand, and I'm sure, it would be greeted with laughter, but, criminal investigations fall generally to the police to conduct. So you end up with a rather circular position as far as that's concerned.